Paying for any care you need in later life can be costly. Healthcare costs are the responsibility of the NHS, so these are free whenever you need them. But that's not the case for social care costs, which includes help you may need with the daily activities of life, such as washing, eating, or getting around. Depending on your financial situation, some or all of your social care costs may be paid by the local authority. You can check out another video in this series for the current rules, but the majority of people have to contribute something towards these costs. There are legitimate steps that you can take as part of your inheritance tax planning to pass on your assets to your loved ones, but you're not allowed to intentionally dispose of assets such as money, property, valuables, or income in order to have your social care costs funded by the local authority. This is called deprivation of assets, or the deliberate deprivation of assets. Local authorities have a statutory duty to charge for the cost of care when you have the means to pay. If you deliberately get rid of or give away assets in order to get your care paid for, the local authority can charge you as though you still had those assets. So what exactly is considered deliberate deprivation of assets? There may be justifiable reasons you might give away some assets, for example, some forms of inheritance tax planning, as I mentioned before. So the local authority must show why their investigation has come to a deliberate deprivation conclusion with reference to one of the following criteria. The first is intention. This means that the intention to avoid care charges must be a significant factor or the only reason for someone to transfer an asset elsewhere. The second is foreseeability and/or timing. The rules state that it is unreasonable for a local authority to decide someone has disposed of an asset to reduce the level of care charges if at the time the disposal took place they were fit and healthy and could not have foreseen the need for care and support. So you need to be more mindful when it comes to giving away assets close to the time when care is needed. Many grandparents help out their children or grandchildren financially by taking advantage of the gifting rules for inheritance tax planning. When it comes to gifting and deprivation of assets, the local authority might deem gifts as deliberate deprivation if they consider the gifts have been made specifically to avoid paying for the cost of care. As already mentioned, they have to prove that intention was there. A statutory guidance states people with care needs are otherwise free to spend their money as they see fit. The consequence of deliberate deprivation can be quite severe. The local authority has four options. The first is called notional capital. The local authority will act as though you still have the asset for the purpose of the financial assessment. However, if your assets actually reach zero and you have no capital from which to fund your fees, then the local authority will still have a legal duty to meet your assessed needs and will have to ensure that the care fees are paid. Their second option is called notional income. This means the local authority will treat you as having notional income. Notional income is the income that you're treated as having, which you may not actually have. Examples are income that would be available on application, such as a benefit, but you haven't applied for. Income that is due to you, but you haven't received it. And the example we're discussing here, income you have deliberately deprived yourself of to reduce the amount that you must pay for care services. The local authority's third option is powers of recovery. If you transfer your assets within 6 months of you needing care, the council has the power to pursue the recipients of the gift and reclaim the cost of care from them. Finally, the fourth option is the Insolvency Act. This is the final port of call for local authorities and not an option that's been used much to date. But there is a view that it may become more popular due to budget restrictions for local authorities. The way that it works is if a deprivation is considerable in value but does not satisfy the 6-month rule for powers of recovery, so it took place more than 6 months before you needed care, then the local authority might attempt to recover the money through the courts by using the Insolvency Act. Alternatively, the local authority might treat the care fees as an accruing debt and aim to recover the money in the civil courts. So, what if you want to challenge a decision? A local authority must use discretion when considering if there's been a case of deprivation of assets where they undertake your financial assessment. This means that they must genuinely take all relevant facts and explanations into account and clearly explain why they have reached their decision. If you believe the local authorities reached the wrong decision, you should ask for a written explanation of their decision, giving the local authorities reasons for deciding there has been a deliberate deprivation, and challenge it through your council's formal complaints procedure. If this isn't satisfactory for you, you can lodge a complaint to the local authority ombudsman. Thanks for checking out my YouTube channel. I'm Justin King. My aim is to help people live successful lives, and that often involves understanding your money. I hope you've enjoyed this video. If you have, please press the like button to help more people like you find my channel, and check out the show notes for some useful links on the things I've discussed in this video, and for links to other videos on finding and funding care in later life. For now, I'm Justin King, helping you live your best life.